This short video is designed to help you as you prepare the Exxon versus Allapattah case for class. This decision often makes students a little bit confused. It's a challenging decision to read through, and this video will hopefully help provide you some background information and some strategies for thinking through both the majority and dissent. Our takeaway goals for class are: I want you to be able to understand the majority's holding and be able to apply the decision to new sets of facts. I also want you to learn how to identify and to make persuasive arguments from both black letter law and from policy. In order to do especially the latter, you need to understand the arguments presented by the dissent opinions, so don't focus solely on the majority opinion. Lastly, I'd like to spend a little time in class using this decision to critique the use of legislative history. To begin, Exxon deals with some difficult questions of party joinder. So for a moment, let's review what the federal rules of civil procedure permit people to do to join others in their lawsuit. Specifically, Rule 20 of the Federal Rules of Civil Procedure allows a plaintiff to add multiple plaintiffs to their suit. In the hypothetical you see here, Paul from Arizona is suing Donald from Ohio, and then Rule 20 would permit Paul to join Penelope as an additional plaintiff, also suing Donald. In the first hypothetical I have written for you here, we'd ask ourselves, what would happen if both Penelope and Donald were from Ohio? Well, one question we'd have is this would destroy diversity. Penelope on one side of our V would be from Ohio, and Donald on the other side of the V, the other side of the controversy, is also from Ohio, which is a destruction of diversity in a diversity action. Another variation would be that let's assume Penelope is from a diverse state of Donald, so let's put her in Nebraska. But let's assume, unlike Paul's suit against Donald, which we are going to suggest is a $90,000 dispute, Penelope's dispute with Donald is only for $50,000. Again, we have a problem with the diversity rules, in that the suit Penelope versus Donald doesn't meet the requisite amount in controversy. And because of the limitations on aggregation, we're not allowed to add up the amount that Paul is suing Donald for with the amount that Penelope is suing Donald for. You need one plaintiff and one defendant in order to permit aggregation. So it seems if our only basis for this coming in is diversity, we'd have a potential B-bar problem. Remember, 1367B says you don't have supplemental jurisdiction if you have a diversity action and you have certain types of joinder that would basically undermine the jurisdictional principles of diversity actions. If you were to look at the actual language of 1367B, and I encourage you to do that again right now, so you can pause the video, look at it again, and see whether or not there's an express grant or denial of this type of joinder, you'd quickly see that this joinder, additional plaintiffs joined under Rule 20, is actually not expressly listed in the limitations of the B-bar or the list that would trigger the B-bar under 1367B. This is one of the problems that's actually addressed in Exxon. One of the suits that's joined here in this case is that very situation, where we have plaintiffs using Rule 20 to add an additional plaintiff against a defendant. In our variation here in the Exxon decision, the Exxon case, the second plaintiff fails the diversity rules because they fail the amount in controversy requirement, not the citizenship requirement. And that's important to remember as you're reading through the decision. In this case, what you had was a child who was pretty seriously injured on a tuna fish can. They sue Starkist Tuna Fish for a claim in personal injury damages. The amount in controversy for the child's injuries are over $75,000. The family are claiming basically consortium claims, and their claims do not amount to greater than $75,000. So these additional members, while diverse from Starkist, do not independently have the amount in controversy met. And so the question before the court is, even though this is not listed, Rule 20 joinder of multiple plaintiffs in the 1367B bar, is this otherwise barred? The other case that's joined in this dispute deals with a class action. So let's review for just a moment the subject matter jurisdiction rules for class actions and diversity cases before the decision you're reading now. In prior decisions, the courts held that when you're considering what citizenship we're going to give to the class, you look only to the class representatives. When considering what the amount in controversy is, before this decision, the claims that we considered, the court told us in 1973 in a case called Zahn, that every single plaintiff member of the class, not just the representatives, must meet the amount in controversy requirement in order to be joined in the suit. So in other words, the class action didn't qualify for diversity jurisdiction if every plaintiff class member didn't independently meet the amount in controversy requirement. So let's look at what actually happened in this decision. In our case here, we have the class action that's joined with the tuna fish injury, the Rule 20 plaintiff joinder. Here, the class action suit dealt with dealers who were arguing unlawful practices by Exxon. And for our purposes, the facts are not as relevant at this moment. I want you just to focus on the setup of the joinder. We have dealers 1 through 5 who each have claims amounting to over $75,000 in damages, and you have a class of other dealers 5 through 10,000 whose claims are much smaller. And none of them have an amount in controversy over $75,000 against Exxon. So the representatives do, but the class itself does not. All right, in this case, the dealers brought their class action in federal court, arguing that Exxon had intentionally overcharged them on the price of fuels as part of their monopoly. And here our question is whether or not 1367B has an express denial or grant of supplemental jurisdiction when you have joinder under Rule 23. So again, we have a diversity action as our basis for coming into federal court, claims that otherwise don't have any independent basis for being in federal court, coming in under 1367. We know that that typically is the first part of the trigger of the 1367B bar, a claim solely based in diversity. But if we were to look at the claims that actually trigger the limitation under B, we don't see joinder of plaintiff class under Rule 23. So here's the problem. If you look at 1367B, there's a very odd omission for Rule 20 plaintiffs joining and Rule 23 class action plaintiffs joining. If we felt like this omission wasn't intentional, Congress could potentially fix this. We're going to try and do a little of this in class when we talk about this case. So take a moment and look at the statute. How would you amend the statute, or how would you fix the statute if you hadn't actually intended the Rule 20 plaintiffs or the Rule 23 plaintiffs to be omitted from the 1367B bar? You should also ask yourselves, do you think this omission was intentional? And if so, why might Congress decide to not include Rule 20 plaintiffs or Rule 23 plaintiffs in the 1367B bar? After you consider how Congress could actually adjust the text, and that's an important thing, make sure you've paused and thought about that. Next, consider what the court's left to do. Remember, the court is not Congress and cannot redraft the statute. So they're left with a textual problem if they presume that this seems to be something that they didn't assume Congress would like to have left in, especially ones where you think they're permitting a potential destruction of diversity of citizenship. And so the opinions basically have arguments that revolve around the text of 1367B, how they're going to read it, and 1367A, how they're going to read that, in order to actually support their conclusion about whether or not these claims should be permitted. They're going to make arguments from legislative history, and they're going to make arguments from policy. What you need to do is focus on those arguments as 3 separate groups. So look at the majority opinion and consider how are they examining the actual text of 1367A and 1367B to correct the potential problem they believe was left by this omission of Rule 20 plaintiff joinder and Rule 23 class action plaintiffs joinder in the 1367B bar. Do the same for the dissent. How is the dissent reading 1367A to deal with the problem left by the omission of these types of joinder in the B bar? After you consider the textual decisions from both the or arguments from both the majority decision and the dissent's decision, I'd like you to look at their arguments with respect to legislative history. How are they taking legislative history into account? Do they consider it something that they should look to? Have they made a persuasive argument that legislative history is appropriate to look at? Do you think the legislative history actually supports their argument? So take all the arguments that deal with legislative history, whether or not it's something they can consider, and then what they think it says, as a separate sort of bucket when you're making your notes about both the majority opinion and the dissent opinion. And finally, consider the arguments, the policy arguments that the majority uses to support its decision and that the dissent uses to support the dissent's opinion. Again, this is a third category of arguments. When you're considering them, ask yourself, who do you think has the stronger argument here? You might ultimately agree with either the majority or the dissent in the end, but what part is the most persuasive for you? Is it their textual interpretation, their use of legislative history, or the policy arguments they've made? We're going to flesh these out in class and consider them in more detail. That's where I'd like you to focus as you prepare.